Good morning. Welcome to oral argument. Clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in Los Angeles, California on Thursday, December 7th, 2017 at 9 a.m. Case number S236208, Keller Ehrman LLP, plaintiff and appellant versus David Wright Tremaine LLP, defendant and respondent, and related cases. For appellant, Mr. Christopher D. Sullivan.
Ready.
For responding, Jones Day, Mr. Shai Kevorski.
Ready.
And for respondent, Ulrich Carrington and Sutcliffe LLP, Mr. Eric A. Chomsky.
Ready, Your Honor.
Case number S232607, Hector Alvarado, plaintiff and appellant versus Dark Container Corporation, California. Defendant and respondent for appellant, Mr. Dennis F. Moss.
Ready, Your Honor.
For respondent, Mr. Howard B. Gold.
Ready, Your Honor.
And for Amici Cura, California Employment Law Council and Employers Group, Mr. Zachary P. Husky.
In the first matter, Heller Ehrman versus Davis Wright Tremaine LLP and related cases, we welcome the Honorable Nora M. Manella, Associate Justice, Court of Appeal, 2nd District Court, 4th Division. You may proceed, counsel.
Good morning. May it please the Court. Chris Sullivan, Diamond McCarthy, on behalf of Heller Ehrman LLP. The question before the Court today is a pure question of California state partnership law. The answer to that question is found in the established rules as codified in the Revised Uniform Partnership Act, RUPA, which itself builds on 150 years of established California case law. These rules include the unfinished business rule, which provides that a partner has a duty to account for the profits from pending but uncompleted matters that they complete at their new firm.
Counsel, why should Heller be paid for work it didn't do, particularly if it's already been paid for work it did do?
Because a critical factor, Your Honor, is that the partners of a dissolving partnership remain partners of the dissolving partnership until the work is completed. So that work is being completed by that partner on behalf of the dissolving partnership. And that's why there's a duty to account that is expressly codified in 404B1 and reinforced in...
So let me just connect that answer to my question. So I hear you saying the reason is because the partners that are doing the work are still partners of the dissolved firm, and so they owe a fiduciary duty to that firm, and they have no choice but to finish the sentence?
Yes. They have no choice but to complete the work on behalf of the partnership. I mean, that goes as far back, of course, to Little v. Caldwell and Osmond v. McGrath, which this court decided
Unless
in
the
1800s.
client doesn't want it to happen that way, or what role does the client's decision play in that process?
The client's decision is to continue the case with the partner of the dissolving firm. The partner of the dissolving firm is a partner of both the dissolving firm and the new firm if they join a firm or they're in their solo practice, because it's unique to the nature of a dissolving partnership.
Are there any limits on that, counsel, in terms of how long that tail of work can continue?
No, you need to define the uncompleted matters by virtue of the nature of the matter involved. And that was the holding in Grossman v. Davis, where they found, the California Court of Appeal found that a collection action that went hand in hand with actually getting money to the firm after having won a contingency case was considered winding up that matter.
You're classifying it then. You're classifying them by matter, which is to say, if there's a case in litigation or there's a negotiation of some sort in progress, those things can be completed. But if you have a large institutional client of the law firm with potentially lots of matters, new matters do not fall within your rule.
They absolutely do not. And so it's the client relationship that the partner brings to their new firm is hugely valuable. And the record reflects this in the underlying cases. There was one client alone that brought $24 million to the new partnership within a year and a half. So it's only the uncompleted matters that are at issue.
So is it a mandatory rule or default rule? Let's suppose that
it's a default rule.
Okay. So in your understanding of the world, the client could still say, I want you to continue to represent me, but I don't want it to be the dissolved firm. I want it to be the new firm, and that would trump.
No,
Okay.
I don't think it's the client choice. I mean, the client is retaining the case, and the client doesn't have control over how the fees are divided.
So this is important because I'm now understanding more and more your position. So your position is because of that fiduciary relationship, the client, if he or she wants to retain that lawyer, has no choice but to essentially have the firm that has been dissolved get the money from the matter.
Yes, but it's not all the money. I mean, it's the profits minus reasonable compensation and minus reasonably allocated overhead. That's the choice that the legislature has made. But there's many different circumstances by which when a client pays $100 in legal fees, it gets dispersed in a wide variety of ways that a client has no control over. So there isn't a direct relationship in any law firm scenario of any, at least of any size, between the dollars that come in that the client pays and the compensation to the partners.
So can you put a finer point on the understanding of, in an hourly fee situation, why wouldn't the dissolved firm only be entitled to the hourly fee that was earned up to the point of dissolution, rather than continuing to have a tether to an hourly fee earned in the future?
Well, as this court held in Howard v. Babcock, I mean, the hourly cases, the contingency cases, the mixed blend cases are, clients retain law firms in a wide variety of different fee arrangements. And those are the assets, those are the key assets of a law firm.
But doesn't it seem a little bit speculative to treat them as the assets of the law firm when we're talking about work that hasn't been done yet and the bills haven't been sent out? I mean, tomorrow, presumably the client could decide, I want to choose a different law firm to handle this matter. Doesn't it seem strange to treat the sort of expectation that the client won't do that as, in effect, a property interest of the dissolved law firm?
Well, there's several aspects to the answer to that question, Your Honor. First, because it's a duty to account, as it is with others, as it is with partnership business when the partnership is not in dissolution, it's a backwards-looking remedy in that it looks at what really happened. So if the client moves to a different firm, there won't be any future profits to account back for. It's important in kind of understanding that analysis. But also there's a definition of property within RUPA itself in 16-101-15, which says property includes any interest, tangible or intangible, as well as any interest in that property. So the RUPA, again, has answered the question by codifying that an interest is a form of property in a partnership, and that's as it should be.
But it seems, counsel, that in your reading of RUPA then, tell me if you differ with what I'm about to say. In your reading of RUPA, Heller is in a better position having dissolved than it would be if it had not dissolved, in the following sense. If Heller is not dissolved, partner leaves, doesn't have that continuing non-revocable fiduciary responsibility, but if Heller's dissolved, then Heller is entitled to this money no matter what.
Well, Heller would, again, only be entitled to the profits
Right, to
minus
the profits,
reasonable
exactly, fair.
compensation and overhead.
The money we are discussing now.
Correct. The duty to account is clearest in the situation of a dissolving firm. The question isn't before the court today with respect to what the duties might be pre-dissolution. But the firm itself also can contract for that in the partnership, as this court held in Howard v. Babcock. So Heller-Ehrman could have had a partnership agreement that imposed some reasonable toll if a partner or a group of partners left with the firm's most
But it would all be
valuable
subject to
assets.
contract, right? I mean,
Yes.
You're hedging slightly when you say the duty is clearest, but you do agree there's a bit of an asymmetry there, isn't there?
There's a possible asymmetry, again, depending on whether one can interpret RUPA to apply as well to pre-dissolution scenarios, as the 11th Circuit did in a case called Buckley Towers.
Doesn't that produce the perverse incentives that the other side argues? That partners at the first sign of trouble before the firm goes into dissolution will move and not wait around for this duty to bind them, because obviously it's less advantageous at that point.
Well, there are two parts to the answer to that question as well. The first part is no, I do not believe so. I mean, most partnership agreements build in a period of time, a notice provision before which a partner can not depart. But second and more importantly, the partners of a dissolving firm have fiduciary duties to that partnership that are implicated if they are motivated to leave the dissolving firm because they want to take the business free from a duty to account. But most importantly, this is the way that the legislature has drafted RUPA. It's how they have enacted the statute, and they enacted the statute knowing of the California case law. And under ANIA v. Superior Court, that case law that predates RUPA is incorporated within RUPA.
You talked about the definition of property in RUPA. Is there any other provision that you think is even more on point here in RUPA that directly supports your position?
Well, there's 16404B1 and how it was interpreted by the courts and was well known to the drafters of RUPA and discussed. There's 16401H where they retained RUPA, but they modified it to provide specifically that a partner can only be paid for services rendered in winding up a dissolving firm, except it allowed a provision for reasonable compensation. So all the indicators are, as a matter of statutory construction, that there was a conscious decision to keep the unfinished business rule in RUPA as it had been in the Uniform Partnership Act, but to modify it by allowing for reasonable compensation.
How do you define winding up?
Excuse me?
How do you define winding up within the meaning of RUPA?
It's completing all the matters that are in process at the time. And that's an excellent question, but this has consistently been applied since the United States Supreme Court's decision in Denver v. Roane in 1878, this court's decision in Osmond v. McGrath in 1886, Little v. Caldwell in 1894. They have always characterized consistently winding up as being the completion of the matter to the end.
Does the legal matter belong to the client or to the attorney?
The legal matter absolutely belongs to the client, but
And the client can go to whomever he or she wants.
Yes, but the partnership retains a contractual and statutory interest in the profits if the client remains with the partner of the dissolving firm.
And Mr. Sullivan, the comment in Jewel that once the client's fee is paid to an attorney, it's of no consequence to the client how it's allocated. Isn't that just wrong? Isn't
No,
that
I don't know.
factually wrong?
No, I don't believe so, Your Honor, because, again, there's many different circumstances that relate to how a client's fees is paid
Well,
once
then let
it
me
goes
be a
into
little more
a law
precise
firm.
in my question.
Sure.
If the client's ability to retain counsel of his choice is impinged upon by a rule, then doesn't the client care?
But the only reason, the only evidence that any clients are concerned about it comes from the lawyers themselves. There isn't any...
Well, but as a matter of fact,
As a matter of fact.
if a partner leaves the firm, goes to a new firm, and announces to the new firm, by the way, you're not going to get the profits of my work for this client, and the new firm then discourages the taking on of that client, doesn't the client care?
Well, the firm has a duty to zealously advocate, and they shouldn't discourage the firm from taking the client on, and the partner has a fiduciary duty to continue to work on that case as part of the winding up process.
And the new firm is expected to turn into, for purposes of that business, an eleemosynary institution.
Well, it still gets reasonable compensation and overhead, and gets the
It
tremendous
doesn't get the profits.
benefits.
The law firms are in the business of making money, unless they're firms that have to dissolve because they don't.
But the profit includes both compensation and additional money beyond the reasonable compensation.
But here's another
which is-
version of, sorry,
Please.
here's another version of Justice Manella's question, which I think, gets at an asymmetry in your argument, perhaps. A premise of your argument is that the relationship with the client is extraordinarily valuable for the law firm. That's
Yes.
why we're here, right?
Right.
Why isn't the reverse also true? Why isn't the relationship with a law firm very valuable to the client? The choice of law firm, the expectation of a reciprocal relationship in the future, the accumulation of expertise about the client. And in that sense, why isn't it entirely plausible that a client would care who the profits are going to?
Because it happens in any number of situations in which, for reasons known or unknown to the client, there might be severe difficulties that are encountered by a law firm that make the working on the case less valuable. There's a whole host of situations where lawyers apply themselves diligently and with zealous advocacy without regard to a pure monetary motivation.
I don't want to keep on pressing on this indefinitely, but I'll just take another pass. Assuming we're in a world where the client knows what's happening, perhaps, like, your rule applies, the partner of the dissolved law firm is now in a different law firm and says, look, you should just know I'm going to zealously advocate, but the profits are going to go to the dissolved law firm. So in this scenario, the client knows. I wonder if it's not something you would acknowledge, that the client might say, that's not my first choice, that's not the way I would like it. But you could say back to me, but my argument is strong enough, rooted in RUPA, et cetera, to just trump all that.
And that is what I believe and what the evidence is borne out, because the unfinished business rule has been the rule, and it hasn't had the negative impacts that are projected to it. So this is a policy decision that has to be decided by, and has been decided by the legislature.
Are you aware of any cases other than the Rothman case in which courts have applied this approach in the context of hourly fee matters as opposed to contingency fee matters?
Yes. In by far, the strong majority of cases that have considered the question across the country have applied it to hourly and contingency fees equally.
In California?
Not expressly in California, but there are cases, of course, whether they're published or unpublished, that have applied that rule to hourly cases without question. The Supreme Court of Nebraska follows the rule. The D.C. Court of Appeals in Beckman v. Farmer follows the rule. So it is the majority rule. Any courts, with the exception of the Thielen decision, that have specifically addressed the question of whether the unfinished business rule applies equally to hourly and contingency cases, have said they do, and for good reason, because the partnership, the efforts are when a law partnership gets clients in the door and gets valuable matters, that's the product of a team effort of all of the partners, and even of the employees, of the associates, the employees, the paralegals. It's an effort that this court recognized in Howard v. Babcock, and to me is very real. It's not just one person who's responsible for getting the valuable cases in the door. It's the work of the partnership as a whole, and that's the fundamental fiduciary underpinnings of the unfinished business rule.
This is an hourly rate case, but in a contingency fee case, what remedy does a law firm have if the client chooses to hire new counsel?
Well, in that situation, the law firm has a quantum merit claim, but the issue here is whether they have rights vis-a-vis their former partner. That's what's at issue here.
Can I return you, counsel, to the definition of winding up? Why should we read winding up to be as expansive as you suggest? I mean, the Corporations Code refers to winding up in the following terms: preserving the partnership, business, or property as a going concern for a reasonable time, prosecuting, defending actions and proceedings, settling and closing partnership business, disposing, transferring partnership property, discharging liabilities, distributing assets, settling disputes by mediation or arbitration. That does not sound like continuing to do the ordinary work of the firm going forward.
But there's more than 100 years of California case law that consistently uses the definition of winding up to include completing all the uncompleted transactions at issue. Again, there's the Osmond v. McGrath, Little v. Caldwell. There's also a Supreme Court case, Smith v. Ball in 1958, that dealt with an advertising agency that specifically describes the difference between new contracts that are entered into after the date of dissolution and uncompleted contracts. So RUPA and the Uniform Partnership Act embrace this common law, uniformly applied definition to winding up that has never really been questioned before until this case or these series of cases.
If your argument pivots, counsel, in response to Justice Liu's question on the notion of uncompleted transactions, what's the best support for the conclusion that the transaction includes the continuation of hourly work indefinitely until the matter is done versus, a series of transactions for paying for work on an hourly basis?
Little v. Caldwell, the clear line of cases that has always applied the definition of winding up to include finishing those matters, of which the drafters of both the Uniform Partnership Act and the revised Uniform Partnership Act were acutely aware.
So your argument is that the revised Uniform Partnership Act did not create the situation you're talking about, it simply incorporated pre-existing law.
It did both. It incorporated the common law as well as the provisions of the Uniform Partnership Act that had developed the unfinished business rule. It started out as Civil Code 2459, moved into California Corporations Code 15021-1. That was the provision at issue in Jewel. So yes, that is the correct statutory interpretation.
Counsel, you have 10 minutes on rebuttal, or use your time now.
I'll save it for rebuttal. Thank you, Your Honor.
Good morning, Your Honors. I'm Shai Dvoretsky with Jones Day. The central principle that resolves this case is that law firms are entitled to be paid only for the work that they do, no more and no less. Hourly cases that a dissolved firm cannot handle and that the client takes to a different firm are not the dissolved firm's unfinished business. Any other rule would severely threaten the access of clients to the counsel of their choice, because it would deny profits to third-party firms that have no obligation to take on a matter in the first place.
How should we read winding up in RUPA?
Winding up does not consist of completing the matter for years on end through potentially Supreme Court review. Winding up in the context of an hourly rate representation simply means fulfilling the lawyer's obligation to the client, not committing malpractice by leaving a brief unfiled, for example, and otherwise transitioning the matter to a new firm. At that point, once the client has retained a new firm, and once Heller announced that it was no longer representing clients, it was no longer in the business of providing legal services, at that point, Heller's partnership business was wound up, and the matters became the partnership business of the new firms that clients retained.
Okay. So the argument from the other side is that they differ with you, obviously, on the definition, but more fundamentally, in terms of the economics of how clients come to law firms, the argument is that it's artificial to think of individual partners as sort of getting credit for certain kinds of matters, that the credit really is shared widely in the law firm. Law firm has a kind of capital, if you will, and the partners are really riding on the capital of the firm, and so when they take their matters elsewhere, they are also, in a sense, they're leveraging the previous capital of the firm, and thus they should be held to account. Is that an accurate view of how clients come to law firms? And if not, what is the accurate view?
No, Justice Lewin. Let me offer two responses to that. One is in the record of this case, supplemental excerpts of record 47, 50, 62. There are declarations there from former clients of Heller, new clients of Jones Day, and there are similar declarations in the records for the other defendant law firms here, that the clients specifically hired firms. To be sure, they considered the fact that a former Heller shareholder was part of Jones Day or part of Orrick, but the clients attested that they would not have hired that individual shareholder to perform the work alone. They looked to the defendant law firms in this case because of the attributes that those firms brought to the table, and that is reflective of the nature of the sorts of legal matters that we're talking about. These are not matters that are simply handled by individual lawyers. They are handled by firms. As for Heller's capital, whatever capital or whatever investment Heller might have made to try to get this case to get a particular case was a cost of doing business for Heller. And Heller recovered for that cost of doing business when it was compensated on an hourly basis for the work that it actually did.
Why is that? Is that empirically true? I mean, in the sense that when firms go after matters, they are essentially acquiring for themselves a future stream of income and profit from that matter. Isn't that how firms think about matters? Is that, should we do this, should we not? How much effort should we put into it? You would want to think about what the future stream of income is.
but at most that future income stream is an expectancy. It's not a property interest. It's something that is not guaranteed, that the client can at any time take away by hiring another law firm. And the trustee in this case concedes, in fact expressly conceded in the bankruptcy court, this is at further excerpts of record 4 from the Ninth Circuit, that if a partner had left a firm before its dissolution and the client had followed that partner to a new firm, in that instance, the old firm would have no claim whatsoever. And so, for sure, law firms consider what the future income stream might be if a client allows the firm to continue handling the case. But there's no guarantee of that. There's no legally protectable interest in that. And there's no legally protectable interest in that that somehow arises upon dissolution at the precise moment when the dissolved firm announces to the world that it can no longer represent the client.
Except for winding up, right? I mean, so again, we go back to the winding up question, and I wanted to just pursue Justice Liu's line of questioning by asking you, the answer you gave him about what winding up meant to you, where does that come from? Is that rooted mostly in your reading of RUPA or case law predating RUPA, or do you think it's the most reasonable understanding of the economics? Like, where is that coming from?
I think it's the most reasonable understanding of the term winding up, and that nothing in the cases on which the trustee relies here is to the contrary. All of the cases on which he relies, with the exception of the one Rothman case from 25 years ago, all of those cases are contingent fee matters. And in the contingent fee matters are fundamentally different, because in that situation, the dissolved firm has not been compensated for its work in the matter. And in a sense, the dissolved firm, therefore, does have a property interest. It has an investment in the case, not the kind of investment that Justice Liu referred to about getting the case, but it has an investment in the work that it did that is, in a sense, stranded in the case that's now being handled by somebody else.
Isn't that a matter of degree? That's really just a matter of degree, isn't it? It's not a matter of kind. Because the first hour that is billed on a matter that comes in doesn't cover the cost of what it took perhaps to land the client or the whatever assignment of resources that the firm is about to make to the matter. So you have to kind of let that matter go on for a bit before you can sort of say, okay, this was sort of worth it for the firm. Don't you?
No, Justice Liu. The first hour doesn't have to cover the cost of getting the matter. The first hour has to cover the cost of performing that hour of work. How the law firm sets its hourly rate for that hour of work will inevitably incorporate the law firm's overhead. And part of the overhead is maybe the business development expenses or other expenses to get the matter. But that doesn't mean that in that first hour, your full overhead to get to that point is necessarily covered. Law firms have overhead and make investments in all sorts of ways. They may, for example, invest in training for their associates. They may invest in new office space.
Can I ask you a clarification of your argument? I understand you to say that this hourly fee, future hourly fee, is a speculative matter. It's not a property interest, therefore it should not then inure to the benefit of Heller Ehrman's dissolved partnership. But the question I have is, does your argument rest on RUPA, or does it rest on policy arguments, or does it rest on case law or combination thereof? I know that the opposing party actually relies on RUPA and the winding up and the accountability and the fiduciary duty and the nature of a partnership. But what is it that you're arguing in terms of, where's the strength of your argument? In RUPA or in case law or the definition of property?
Our argument rests on what a law firm's property interest is. And under California law, a law firm's only property interest in a matter is to be compensated for the work that it did on the matter. That is the
And would that have been equally true before RUPA came around?
Yes, that would have been equally true before RUPA.
So you're not relying on the changes wrought by RUPA?
One of the distinctions of the cases on which the trustee relies is that RUPA does make changes that eliminate the underpinnings of those cases. However, the key point that we rely on is that RUPA itself does not tell you what property a partnership holds. RUPA tells you how to divide existing property interests. As the New York Court of Appeals recognized in Thielen, however, RUPA doesn't tell you what partnership property is. And the partnership property of a law firm includes only its right to recover for work that it did. That is the lesson of cases like Fracas from this court.
So what do you make of the definition of property in RUPA?
The definition of property simply says that the law firm is entitled to its property, real, personal, or mixed, tangible or intangible, or any interest therein. But a law firm does not have any of those things. It does not have a property interest. It does not have any other interest in recovering for somebody else's work. It only has an interest in recovering for the work that it did itself. And again, that's the lesson of cases like Fracas, which hold that a client has the absolute right to discharge a lawyer at any time, and the lawyer at that point is entitled only to the reasonable value of the services that the client actually allowed the lawyer to perform.
So the court in Thielen agreed with you? Is your friend on the other side right when he says that it's a minority view?
It is not a minority view. In fact, the court in Thielen is the only one.
So he is not right?
I'm sorry, Your Honor?
So he is not right?
He is not right. The court in Thielen is the only case to have considered the actual question presented here, which is in the context of hourly matters that a dissolved firm can no longer handle and that a client hires a different third-party firm to handle. What interest, if any, does the dissolved firm have? And the New York Court of Appeals unanimously held in Thielen that the dissolved firm only has an interest in being paid for the work that it did. And it held that recognizing the paramount concern for the interests of clients. Because if the rule were otherwise, clients would not have access to the counsel of their choice in the same way. It would lead to an unjust windfall for an estate like Heller's that would be claiming a right to an indefinite future income stream that could go on for years and years without doing any of the work or taking on any of the risk that the firms actually performing the work are taking on.
What is the nature and scope of the fiduciary duty that the departing partner owes to the dissolved law firm?
The nature and scope of the fiduciary duty, if there is any partnership property, for example, if after dissolution a client sent a former Heller partner, former Heller shareholder, a check for work that Heller actually did, in that situation, that would be Heller's partnership property, and the former Heller shareholder, even after dissolution, would still have a fiduciary duty to account back to the Heller partnership for that. But the fiduciary duty only applies to Heller's partnership business, not to Jones Day's partnership business. Once the former Heller shareholders, once Heller dissolved and the former Heller shareholders ceased to be Heller partners and became Jones Day partners, their duty going forward was to do the work of Jones Day. And when clients hired Jones Day and the other defendant law firms, the work at issue became the partnership business of those new firms. Mm-hmm. In terms of other, responding to Justice Chin's question, other key points that the Thielen court recognized. If the trustees' rule were the law, it would create a perverse run-on-the-bank mentality where partners would have an incentive to flee at the first sign of trouble. Because
what is the that argument is prominent in the briefing. What's the evidence that that is so? I mean, the other side says, well, there are other kinds of duties that mitigate against that happening already. And so what is the incremental kind of perverse incentive that is created by the asymmetry of the in-dissolution versus not in-dissolution situation? Why? I mean, I know that's a prediction you're making, but what reason do we have to think that this will actually come to pass?
The New York Court of Appeals, I think, recognized that it would come to pass as a matter of basic marketplace economics. There isn't evidence of it coming to pass because the trustees' theory here is so novel. It was first asserted in the Brobeck bankruptcy in 2008 or 2009, and before that, there simply was never a claim of this sort. In fact, it's quite telling, I think, that Rothman is the only case in California law ever applying the unfinished business doctrine to hourly rate matters. This is a novel theory that has not been pursued before. And so do we have evidence of law firm collapses being caused by this? No, but as a matter of basic economic sense, this is a reasonable prediction of what might happen.
So your argument is, excuse me for interrupting, your argument is basically that we don't need a factual record. We need to look at what the rule articulated by the trustee would incentivize and simply say what kind of idiot would not leave at a sign of, or consider leaving, when he or she knows that that book of business will go to the new firm, and what new firm, wouldn't be happy to hire someone before the firm is in dissolution. And it becomes, and the new firm becomes a nonprofit organization for purposes of the new business.
Yes, Justice Manella, and beyond that common sense notion, you can also look to the numerous amicus briefs that have been filed in this case from all across the spectrum of potentially interested stakeholders, from the American Bar Association, from the Los Angeles and San Francisco County Bar Associations, explaining what would be the effect on clients and how clients would suffer if, in fact, the trustees' rule became the law.
So I take it you do disagree with the language in Jewel that the client really doesn't care where his money goes?
But we disagree with that as a matter of common sense. It's belied by the record in this case. It's belied by the American Bar Association's brief and the San Francisco and Los Angeles County Bar Association's brief. It's inconsistent with California professional ethics rules, which require disclosure and client consent before a fee can be split. And that rule recognizes that, of course, clients want incentives aligned between the lawyer and the client, and you do that as a matter of basic economics by making sure that the law firm that's performing the work actually gets to keep the profit from the work. To get back to Justice Liu's question, because I want to finish my answer about why existing fiduciary duties wouldn't keep a firm together, RUPA makes crystal clear under California law that a partner can withdraw at any time, rightfully or wrongfully, and wrongfully is defined as a very limited set of circumstances that don't include this kind of scenario. The California legislature, in enacting RUPA, recognized that law firm partnerships are not like Hotel California. You're free to leave. And the trustee has conceded that when a partner leaves outside the dissolution context, there's no duty to account for a matter that the client chooses to take to that partner's new firm. And so it simply as a matter of basic economics, the trustee's rule would create the perverse incentives.
Surely there are other constraints, though. I mean, in terms of duties not to compete, and I mean, you couldn't have a wink and a nod side agreement when the partner is leaving that the client is then going to follow. That would clearly be a breach of the duty to the partnership in advance of leaving.
If the partner solicited the client before leaving, that would be a breach of a fiduciary duty under RUPA. But the client is expressly free to solicit the client. This is RUPA 404b3. The client is expressly free to solicit the client after departing the firm.
Let me just get clear on your argument about how this hurts clients. The suggestion is that you said there ought to be an alignment, right, of the incentives. Is it that clients, on a certain view, clients don't really care where their money goes? Is the suggestion that clients simply wouldn't hire Jones Day or wouldn't hire Oric or these new firms if they understood? Or rather that the lawyers wouldn't take these matters because they are not actually, the firms, right, Jones Day, wouldn't actually take these matters because they're not actually getting paid. All that money is then going back to Heller Ehrman. So it's not really the client's problem, it's the law firm's problem, right? It's the law firms that are really, here alleging an injury. But you phrase it as the client's, impeding the client's access.
2 points, Justice Liu. The first is that law firms don't have an obligation to take on these matters in the first place, and the clients are the ones who suffer if their matters don't find new homes as readily as the clients would like. That is the injury to the client's interests, not to the law firm. The law firm will go on whether it takes on a particular matter or not, but clients will suffer if their matters are disrupted. The second point is, again, clients in this record attested that they do care once a law firm does take on a matter who gets to keep the money. Because, again, they want the interests of the lawyer and the interests of the client aligned by that fee arrangement, and that is what the California Rules of Professional Conduct recognize by placing restrictions on fee splitting.
So the argument is that if you worked on a matter at Heller and then you went elsewhere upon Heller's dissolution and the client wanted to keep you as their lawyer, one possibility is that you, now as a Jones Day lawyer, would not take this matter because Jones Day, as a firm, would be, under the trustee's rule, would be sort of looking at it and say, well, there's nothing in this for us. All the money you would make on working this matter would be going elsewhere. And so Jones Day wouldn't take the matter. And so the client would be out of luck with respect to the counsel of their choice. It would have to presumably get counsel, but get non-former Heller-Ehrman counsel. Is that the margin we're talking about in terms of when you say impeding access to counsel or impeding access to choice of counsel?
It is, but let me emphasize that that's a significant margin because the client may have a strong interest in the continuity that representation provides by having a former Heller shareholder involved. That does not mean, however, that the client is just hiring the former shareholder. Clients do care about more than just the individual partner. They care about the firm as a whole and the resources, the capital, the assets, the reputation, the approach to client service that the firm as a whole brings. Clients.
I'm wondering why that argument doesn't work against you, because that's the same argument that your colleague on the other side made at the beginning about why it is that Heller should get to earn that money later, because after all, that same argument applies to Heller too. When Heller brought in these matters, they too devoted their reputation, capital, resources, the training they invested in their personnel, all those things. And we're back to this sort of future stream of income idea that what they're really doing when they charge an hourly rate. I know you say the hourly rate is set in terms of covering this overhead, but all those resources have already been invested.
But the key point, I think, is that Heller can no longer represent the clients. In other words, Heller invested resources to create a platform that would provide the sorts of things that the law firm defendants in this case now provide. But Heller is no longer providing those things because it went out of business, and it should no longer be compensated for a platform that it created that went under.
But isn't there a difference between the creation of the platform and the business development, sort of the investment that's put into bringing a specific client in the door with respect to a specific matter?
So I think those are potentially two different things. There can be business development expenses in terms of marketing and otherwise, but there are also all of the capital investments that go into creating an international law firm and the reputation that that international law firm has before clients and courts and boards of directors and so forth. And the investments in lawyers that may or may not work on a case at the outset but are available to the client. All of that is part of an institution that a client hires. And when clients are hiring Jones Day or Orrick or the other defendants, they are getting all of that. They are not getting just the former Heller shareholder. And so the compensation for the matter ought to reflect Jones Day's investment in creating the firm that it is, not Heller's investment in a dinner that it took a client to.
I hear that argument, and I understand the distinction you're making, but I think going back to the point that Justice Liu made, it does seem as though there is one piece of your argument here about the value to a client of hiring a firm that just echoes a touch the argument of opposing counsel about why Heller might have reasonably expected that if a client hires the law firm, that the expectation was beyond simply at any given moment where an incremental hour is being billed, the client is sort of like afresh deciding whether to pay for that hour, but instead a more realistic perception, which is grounded both in what opposing counsel said and what you're saying now, but except on Jones Day's favor, is that a client is interested in the law firm as a whole. So, I mean, to me, that leads me back to the question of, like, what the best support is for your definition of property, which you say, I think, is not found in, I mean, there is a definition of property in RUPA, but you're saying RUPA is more about how to divide things that we already understand are property. So,
Mr. Dvoretsky, you may answer the question, but based on how you split your time with Orrick, your time is expired.
Thank you. Justice Cuellar, I think the key point is that clients do hire firms and hire institutions, but the Heller institution and the Heller firm does not exist anymore. And so, therefore, the bankrupt estate of Heller shouldn't be entitled to be compensated for the work that a different law firm is now doing.
Thank you.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the Court. Eric Shumsky, representing Orrick, Harrington, and Sutcliffe. I'd like to start, if I can, by responding to the question you asked, Madam Chief Justice, and see if I can tie in your last question, Justice Cuellar. The strength of the argument here is in the property definition that's contained in the California Civil Code. The bankruptcy law looks to state law to define property law, and the California Civil Law has, the Civil Code has provisions about what constitutes property. It's section 678 into the low 700s. And Justice Kruger, to answer the question that you asked earlier, California law draws this distinction between interests that are speculative, or what it refers to as an expectancy, and other forms of interests. And Civil Code section 700 is quite clear in saying that a mere expectancy isn't just not property. It is, the language of the code section is, it is no interest at all.
How would you describe a contingency matter?
Well,
contingency fee matter.
I'll answer it with reference to the Civil Code again and the cases analyzing it. Marriage of Brown and Marriage of Green talk about the difference between a contingency and an expectancy. And the precise language in Marriage of Brown is, and this is 15 Cal 3rd at 845, the defining characteristic of an expectancy is that its holder has no enforceable right. And that's exactly what we have when we're talking here about these hourly fee matters. For all the reasons that have been discussed already, the old law firm has no enforceable right whatsoever. It is a purely speculative future interest. And Justice Liu, this goes to some of the questions that you've been asking both sides about the investment of capital and the argument that's woven through the trustee's brief about a sort of investment-based theory here. And the strength of it is to say Heller invested, and therefore various things flow from that. But I agree with my friend Mr. Dvoretsky. First of all, that proves far too much. If that were true, that sort of investment right would attach right at the outset, and the trustee has conceded that that's not true, that partners can walk out the door at any time and there's no investment right. But maybe the more fundamental point is that you don't have a property right in every investment. The word investment sort of begs that question. It invites us to think of investing in stocks, and you have something. You have a piece of ownership of that company, but you can invest in all sorts of other things. You can invest in job training, but that doesn't mean you own the employee. It's an investment in some sense, but it doesn't create a property right that someone can get.
So there's a property right in a contingency fee matter? Meaning all the liquid benefit of a contingency matter is tied up in the matter until it's essentially discharged at the very end.
And that's the critical distinction, Justice Liu. It is a right, it is a present right, but it's an unliquidated right. And so all of these cases about contingency fees, the strength of them is a recognition that the old firm actually has something. It has a present, in the language of Brown, it has an enforceable right of recovery.
Do you agree with your friend on the other side that the remedy in those cases is quantum merit?
Yes, cases like Fracas say that generally when you're dealing with the corpus of, or you're dealing with the contingency, you can sort that out by quantum merit. Of course, Fracas also says you can't do that until the end, and that's why, Justice Liu, the right is unliquidated. You have a right to get paid for the work that you did, but it's an unliquidated right.
So, Mr. Shumsky, in what way, if any, does RUPA and its winding up and its accountability, fiduciary responsibility, et cetera, weaken your argument?
So let me answer that by talking a bit about the notion of winding up more broadly. That's something where there are numerous sources here. We have Black's Law Dictionary talking about winding up. We have this court's decision in Jacobson, which talks about what winding up constitutes. We have, Justice Liu, as you pointed out, the litany of things that are enumerated in 16803, which again, to your question, Madam Chief Justice, is part of RUPA's discussion of winding up. None of those sources look remotely like what we're talking about here. The Rudder Group Guide probably puts it most accurately and most colorfully. It says really winding up means winding down. And the idea that winding up could mean working on a matter indefinitely into the future is just flatly at odds with any of those basic sources of understanding.
But if it's a contingency matter, it includes continuing to work on that.
It does, Your Honor, in the sense that the partnership, and this is clear as a matter of RUPA itself, the partnership is not wound up as to that precise thing because, again, and this is the answer I was giving Justice Liu, that property, that interest is unliquidated at the relevant moment.
I don't see. I mean, what is the difference really? It can't really be an investment theory, right? Because the firm could take on a contingency matter and do very little to bring that matter in the door. And really what they're just betting on is the services rendered by the partner during the pendency of the matter and how that partner does, the quality of the work that's done by the partner and, of course, the firm is going to determine the outcome of that contingency fee matter. And in that context, it seems like there's no greater right that Heller Ehrman, no greater or lesser right. It's the same, in other words, because it's the work that's actually done, right, that generates the value. There's no other. It just seems that the two situations are not as far apart as you make them out to be. Whereas where one is some sort of present property, presently held property right. I guess I'm just sort of wondering why is that in the contingency fee situation? What is the theory behind that?
Well, so let me start with precedent rather than theory. Marriage with Brown specifically says, and this is 15 Cal 3rd at 847, that a contingency right is actually a form of a property right. And I think the strength of it, again, is the idea that that old firm has a right to be paid for that work that it did, and it's a right that hasn't been liquidated at the relevant
What work did it do? In a situation where the firm is dissolving and the majority of the work, let's say, is being done later, after the matter has been moved to a new firm, in what sense has the work been done by the previous firm?
Well, so that, I think the answer to that is in the question that Justice Chin asked. That's just a valuation question. If they didn't do very much, then in quantum merit, they won't get very much. The flip side is, if you look at a case like Rosenfeld, where the firm did just about everything, but the partners cut a side deal with the client on the courthouse steps, then the old firm has done a lot and gets a lot.
In that scenario, is the work done by the new firm to litigate the contingency matter to completion? Is all of that work, because it's all necessary to liquidate the property interest that attached before dissolution, is all of that work counted as a property interest that's encompassed within the winding up concept?
I think probably not, Your Honor, precisely because 16401H specifically says that you get reasonable compensation for winding up, and so the new firm would get its reasonable compensation for the work that it's doing, litigating the matter to completion. But obviously all of that is very far afield from anything that we're talking about here. What we have here is exclusively hourly fee matters, all of which Heller had a right to something. It had a right to get paid for the work that it did up until the moment of dissolution.
Why doesn't quantum merit also apply to hourly fees? The more work you do, the more money you get?
Well, I think it does at a high level of generality in the sense that you are getting paid the agreed upon rate that you as a client and your lawyer agreed upon. You decided in advance what quantum merit is. It's your hourly rate.
Is there anything that would change that, rooted in contract law, for example? So can you imagine a situation where a very sought-after firm says to the client, effectively, we will take your matter, but on the condition that if we dissolve, we continue to get the profits even if we are billing you on the hour. Or conversely, that the contract changes the fiduciary duties of the partner that you think currently exists, such that a partner that joins the firm has to promise to provide profits going forward after the firm is dissolved?
So I think the practical answer to your question, Justice Cuellar, is that there actually would be ethical limits on that. The rules against unconscionable fees and fee splitting. What you would have in that circumstance is essentially the firm insisting that someone else is getting paid for the work that's being done, or it's getting paid for the work that someone else is doing. And when you look at the cases like Anderson and Champion and Fracas, or for that matter, Howard versus Babcock, they put outer limits on those sorts of things. I see that I'm well over my time. If I could just offer one final thought here. The Heller bankruptcy was unfortunate. There is no question about that. It was a bad thing for everyone involved. But when Heller dissolved, it stopped being able to do the work of its clients. And when that happened, it stopped having a future right to get paid for that work. That's the simplest rule, it's the fairest rule, and it's the rule that we would ask this court to announce.
Thank you, Mr. Shumsky.
I want to start by focusing on the contractual rights of a partnership to both hourly, contingency, mixed blend fees, fixed fees, upfront fees. It's the contractual right that is key. That's why a law partnership has a right to the contingency matters, because it's a matter of contract.
What is your answer to opposing counsel's last statement? Why should Heller get paid, the trustee get paid, for work that Heller is no longer doing?
Well, first of all, the California legislature has made that decision, but it's the work of the dissolving partner for the dissolving firm, because it is not true that the law firm ceases to exist on dissolution. 16802A specifically provides, and it has always been the case, that a firm continues until the dissolution is completed. So until the matters are wound up, that partner remains a partner in the dissolving firm. That's never really been
How do you define a matter for purposes of your argument? If you say you have a litigation matter and it concludes at the trial level, is the appeal also part of that same matter?
If it continues being conducted by the same partner and in the same client relationship, yes, because it's a continued uncompleted transaction. Mm-hmm. And again, that's the holding in Grossman v. Davis. But the underlying point about how you define a matter is secondary to the question of what is the property interest. This court in 1974 in Abrams and Fox Inc. v. Briney held that a law firm has a protectable interest in an hourly fee engagement, and so it can be protected despite the fact that it's terminable at will from being intentionally interfered with by another party. That goes part and parcel with the fact that if you breach your fiduciary duty as a partner and you take the case to another firm, there is a right that the law firm has against you because of its property contractual interest in that matter that was taken. Those are protectable.
But you're not disputing the basic premise that the client can pick up the matter and take it any time.
Right, but that doesn't prevent this court from recognizing that that's a protectable contractual right. There really is no functional difference between hourly cases and contingent cases in that regard.
You're saying that the only difference is, as you started your rebuttal, a matter of contract,
yes.
that those have been provided for, generally speaking.
The contractual rights are protected. Even though the contract is terminable at will, California law protects the law firm's contractual rights in that situation. It doesn't protect them against being terminated by the client. It protects them from outside interference from third parties. That's real. That is the definition of property. Mm-hmm. That's why a cause of action is property under Civil Code Section 953.
It's hard to see,
It's
though,
not an
outside
expectancy.
interference as the dissolution of a law firm. I mean, I understand your assertion, but here the law firm dissolved. The law firm ended. It's not that there was interference by a partner. There wasn't a fiduciary breach. It was a new day.
I agree, but it illustrates that there are contractual rights that are a form of property that are protected.
Sure.
Contractual rights are protected. They're not a mere expectancy, actually. I mean, the fact that a contingency matter may or may not generate property doesn't make that contract less effective at the date of inception.
But a client's right to vary what law firm gets a profit is not protected, sounds like. And I guess I want to just be clear on whether your answer to the concerns that have been raised about, say, the misalignment of incentives between
Sure.
client and lawyer is, yes, that's a problem, but it's, again, sort of offset by the clarity of the basic law here, or if your answer is more like, no, that's really not a concern.
Both. First and foremost is answered by the statute. I mean, it begins and ends with the statute. If the statute were different, I wouldn't be here. Okay, but I also happen to believe, as the Jewell Court did, that the statute is good policy. I mean, Jewell was a case of statutory interpretation, and then they said, fortunately, it's good policy as well. I do think, on balance, the considerations that favor the unfinished business rule are stronger. They're policy issues. I believe protecting creditors is important. I think lawyers have a responsibility to pay their debts. I think it's good for the legal profession.
As a practical matter, do you see any distinction between hourly fee matters and contingency fee matters?
Well, I mean, I see practical distinctions between hourly fee matters, fixed fee matters, upfront fees, blended rates. I do
But none
them
that
all,
matter here.
But not that override the statutory purposes in the clear California case law. And with respect to Thielen and the question of property and what's a protectable interest, the Colorado Supreme Court, after Thielen was decided, followed Jewell and rejected Thielen and held that the law firm had an interest in the contingency case. And there is no proper analytical difference between the rights with respect to a contingency case and an hourly case in that respect. And the
Is that because
cases on page 39 of my brief go to the states that have followed the Jewell line of cases versus Thielen.
when you say there's no functional difference between the hourly fees and the contingent fee cases, is that because the speculative nature of the future income stream is equally speculative in both instances, and the investment that the law firm, the economics of the way that clients come into these to become a matter for the law firm is functionally equivalent in both instances?
In the sense that matters. I mean, there can be obviously a lot of differences, right?
Yeah.
But some good, some bad. But it's the contractual right that the law firm has to a contingency interest, whether or not it germinates into something that's valuable or not. With respect to hourly cases, it may or may not continue. It might be stronger. And, if there's a lot of speculation about what the policy decisions might lead to, but, if somebody comes to the law firm and says, I represent Google, I think Google might come to my new firm because Heller's going out of business. I'm going to have to finish a few matters and I'm going to get reasonable compensation and overhead costs, but I'm not going to get the profit. But I'm very optimistic that Google might get sued again. I mean, it's a much more nuanced question than the law firm defendants would like us to believe. And the thing that they stay away from the most is the state partnership law and the provisions of RUPA.
Can you tell me what happens in the typical contingency fee arrangement with respect to clients' termination rights within?
Yes. See, there's a key difference between what are the law firm's rights as against the client's recovery versus the law firm and the partner's right against the partner who moves to a new firm. So they're mixing apples and oranges, really, to say if a lawyer has a contractual right in a contingency case that he can reach or she can reach into the client's recovery on a quantum merit basis. That's not from the subsequent firm. That's a different question. Here the question is the rights between partners. If I might close with something, I arrived at my hotel yesterday afternoon, and I got out of the elevator, and there was a frustrated person with a serving tray from room service. And my room happened to be kind of near the elevator, so I went to my door, and she said, "Oh, are you in 16101?" And I said, "Yeah." She said, "I have your room service order for you." And I said, "I didn't order room service." And she said, "It's from your San Francisco family." And by what she meant by that was my law firm. And I recognize that I hope I do good work here, but it's not just mine.
Thank you,
Thank you.
counsel. Thank you all, counsel. Matter stands submitted. Calling the Hector Alvarado versus Dart Container Corporation of California, we welcome the Honorable Stephen Z. Parent, Associate Justice, Court of Appeal, 2nd DCA, Division 6. And when you're ready, counsel, no rush. When you're settled, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Dennis Moss. I represent the appellant, Hector Alvarado. Mr. Alvarado is in court with us today. With me also are Joseph Lavi, my co-counsel, and Richard Quintaloni, who wrote an amicus brief in this case. The Court of Appeal opinion in this case allows the calculation of overtime to proceed on the federal fluctuating work week basis, where the more overtime hours an employee works, the less he gets per hour. Application of the fluctuating work week method of calculating overtime is contrary to 60 years of California authority. The Court of Appeal rationalized this decision with the idea that there was no California law or regulation that specifically said how to calculate overtime when there's a mixed wage scheme that includes an hourly rate and a fixed sum. Here the fixed sum is the Saturday and Sunday sum. The court then decided, because there's no specific law that addresses this situation, we're going to follow the federal approach. The court should have construed and enforced California overtime of 1.5 times the regular rate, just as the court did in Skyline Homes. There's no definition in the wage orders or the laws of regular rate. When that is the case, this court has advised...
So was the Court of Appeal wrong when it said there is no state law to apply because the manual is void because it failed to comply with the APA?
No. The Court of Appeal was correct in saying there's no definition of regular rate in the law, but the DLSE manual, you said in Augustus versus ABM, can inform your decision. And here, you said last year in the same case, when construing the labor code and wage orders, courts are to adopt a construction that best gives effect to the purpose of the legislature and the IWC. Here, the purpose of the legislature and the IWC was directly addressed in the Skyline case, and the Skyline case is referenced in the DLSE manual in Section 48.
Didn't we face a similar situation in Tidewater?
In Tidewater, you did.
And what did we say?
In Tidewater, you said it's not a regulation, but you could look at but in Augustus and other cases, you said your decision could be informed by the DLSE's opinion because of the DLSE's expertise. But here, it should not only be informed by the DLSE opinion, it should be informed by the 60 years of authority. In 1957, the Attorney General said, in its opinion, that fluctuating work week under the federal law does not apply to interpretation of the wage orders.
Is the authority cited in the manual?
Pardon me?
Is this authority that you speak of cited in the manual?
I don't know if the AG's opinion is cited in the manual, but it's cited in the Skyline case. I know in the old manual it was decided, but that's not in the record. In the 1978 manual, they referenced the AG opinion. Oh, it is cited in the manual. I believe it is cited in the current manual, but in the current manual, Skyline is cited, and that's the important thing. Because after the AG's opinion was general. Let me start with that. The AG's opinion did not address salary of somebody whose only wage is a salary, like in Skyline. The question was by the Industrial Welfare Commission to the AG, and it said, is fluctuating work week appropriate? And the AG said no. It didn't say not only in the Skyline context, it applies in any context. And then, what did the IWC do? It got this opinion directly written to the IWC, and it reenacted the wage orders year after year with the same regular rate language. Now, this court has said when legislative entities enact laws that they're presumed to know the AG opinions that preceded those enactments. Here, that rule is magnified by the fact that the AG's opinion was written directly to the quasi-legislative agency that passed the law. Once the IWC reenacted the law with the AG's opinion as a backdrop, it's hard to say that the Industrial Welfare Commission intended that the fluctuating work week apply.
Can I ask you, so beyond that initial question of whether the fluctuating work week approach applies, can you walk us through how you understand the DLSE manual to concretely to instruct that the regular rate be calculated in the context of a flat sum bonus? So I'm looking at the manual provision tells us that if the bonus is for a flat sum, the regular bonus rate is determined by dividing the bonus by the maximum legal regular hours worked during the period to which the bonus applies. What do you understand that to mean? So if an employee works the legal maximum per week of 40 hours, that's fairly simple. But what if the employee works only 30 hours in a week, but more than 8 hours in a single day?
Well, in the more than 8 hours in a single day situation, there's the case of Lujan versus Southern California Gas Company. The respondents have said, well, Skyline only applies to when the fixed amount is a salary for the week. But Lujan versus Southern California Gas Company dealt specifically with the situation where the employees of the gas company were getting an hourly wage typically, but on certain days they got a fixed amount for of money for a day's work. And in that case, the question was, the Southern California Gas Company collective bargaining agreement says you divide that fixed sum by the total number of hours worked. And in the case, they used the example of 10 hours. They said if a person, let's say, gets $100 a day, you divide by 10, and that gives you the regular rate. The DLSE was a party in that case. Mr. Lujan was the labor commissioner.
So it's not divided by the total number of hours possibly worked legally?
No, what the court said...
Is that yes or no?
The court said that you divide by 8 hours.
Because what happens if you divide it by the total maximum possible?
Well, if you divide it by
Doesn't that take you back to your opening sentence, which said more overtime, less pay?
Exactly. And so Lujan said you cannot...
you can't include the overtime hours in the
you have to divide...
denominator.
Pardon me?
You can't include the overtime hours in the denominator, if I understand you correctly.
Because any time the overtime hours is the denominator, the regular rate decreases, the amount decreases for overtime hours. And Lujan said you divide by 8 hours in that situation. Now, ultimately, there was a collective bargaining exemption that did not apply that but that collective bargaining exemption did not undermine the application of Skyline on a daily basis by dividing by 8 hours.
But so my question is a little bit different. So if we start from the premise that we can't include any overtime hours in the denominator in determining what the regular bonus rate is, do we then, it seems to me we have two alternatives. We can either, sort of as in the Skyline scenario following the legislature's effective codification of it, it says that you are to divide the compensation by 40, which is the maximum hours that can be legally worked as regular time, straight time in a week, which would essentially mean that you're excluding the overtime hours, but no more. Or do we instead divide by the number of hours that the employee actually worked, even if it was less than 40? And I think that the conceptual idea here would be that the employee earns a little piece of that bonus every hour that he or she works. So if they get $200 at the end of the week, for each week of labor, no matter whether they worked 40 hours, no matter whether they worked 36 hours, you would say some people earned that in 36 hours, some people earned it in 40 hours, and so we're going to use the 36 hours as the denominator.
I think that's what the approach would require. The whole purpose, you divide by the number of hours they work, but overtime is only an issue if it's less than 40 hours if they work a daily over 8 hour day.
Correct.
And you would divide by 40 hours if the 40-hour rule applies. I think the situation is when the 8-hour day overtime is greater than the 40-hour a week overtime, you might look at the daily amount. You could divide by the daily amount. So I believe, look at the purpose of the law here, as this court decided in Industrial Welfare Commission versus Superior Court, which was relied on in Skyline, the purpose of the law is to not benefit employers by giving them a reduction in regular rate that would incentivize them to work people long hours during the day.
So can I ask you a slightly different question, which is we're talking here about a bonus, a flat sum bonus, that is a little bit different from the examples in the DLSE manual, which are concerned bonuses for attendance each day or attendance through the end of a season. Here we're talking about a bonus for working a full shift on a weekend day, correct?
Well, first of all, I think bonus is a misnomer. I mean, it's not really a bonus, it's a shift differential. And it doesn't fit the definition of bonus under federal law. If there is, for example, a production bonus, then the person, let's say, the employer says, if you manufacture 1,000 widgets this week, I'm going to give you $500.
Yeah.
There you divide by the full amount of hours worked because it's the work performed during the straight time and overtime that justifies that. The same thing with the safety bonus. If at the end of the year they give you a safety bonus of $500 because there's no accidents in your facility, it's based on your safe behavior during regular hours and during overtime hours. This is a fixed amount that has nothing to do with the, excuse me, my mouth is a little dry here. This is a fixed amount that has nothing to do with the activity that occurs during the overtime hours. The legislature,
I'm sorry, so just to bring you back to where you started, so you said it's the same as a shift differential. So is there any difference? Is there a reason from either the employer standpoint or the employee standpoint why it would make a difference whether the employer pays $15 as a quote-unquote bonus for working a full shift on a Saturday versus paying an extra $180 something per hour for a Saturday shift?
There's a huge difference. I mean, throughout California, there are employees who get shift differentials. Like in hospitals, a nurse who is being paid $50 an hour and working the graveyard shift gets $55 an hour. When you calculate her overtime, you're multiplying times 1.5 times $55 an hour. And that is a lot more money than the fluctuating work week.
Right. I'm not. So my question isn't about comparing it to the fluctuating work week. The question is just: is there a difference between paying more money per hour for each hour of the Saturday shift versus paying a lump sum at the end of the shift?
Yes, there's a difference. The difference is if you're paying a lump sum and you do not, and this court doesn't reverse this case, then you get back into the situation of a diminishing regular rate, a diminishing overtime rate for each hour over 40 or each hour over 8 in a day. There's a difference in impact that is extreme. It's a huge difference.
But on your view, under which the Court of Appeal would be reversed, is there a difference?
The Court of Appeal.
So if we were to take the approach to bonuses generally that you would like us to adopt, is there a difference between what we would say about the proper calculation of the bonus rate versus a situation in which we treat this as a shift differential scenario?
Well, the key factor is this is a fixed amount. Whether you call it a bonus, whether you call it a shift differential, if it's a fixed amount, Skyline teaches how you have to deal with it. And it's not calling it a bonus, calling it a fixed amount, calling it a shift differential, calling it anything is not the issue. It's a fixed amount, and Skyline teaches how you're supposed to deal with it. So I'm not sure I'm tracking your question, but that's the way I view it.
I'm just trying to ascertain whether there's a difference from your point of view of how we should instruct that this calculation be performed if we were going to do that, depending on whether we treated this as a bonus of the sort that is addressed in the DLSE manual versus treating it as shift differential pay.
Well, I think the treatment should not turn on the characterization. The treatment should turn on the effect, because the effect is antithetical to what the Skyline case and the Lujan case and the AG's opinion has said is the approach that should be taken in this situation. When AB 60 was passed after Pete Wilson appointed some people to IWC who eliminated the 8-hour day. And shortly after that, AB 60 was passed that brought back the 8-hour day immediately. And in passing AB 60, they said the importance of the 8-hour day, which had existed for 100 years prior to the FLSA, the importance was that it's bad for employees' health to work long hours, and it's bad for family life for people to work long hours. And they said that's very important. And you tie that into the scheme that the Court of Appeal adopted here, and it incentivizes employers to work people long hours, to affect their health and family life, because it gives the employers a break with every extra hour over 40 in a day, over any extra hour over 40 in a week, over 8 in a day, that is detrimental to employees. And what's going to happen if it's not reversed is you're going to see employers reducing the hourly rates of their employees, coming up with so-called bonus schemes that are fixed amounts because they're going to reap the benefits of this calculation methodology to the severe detriment of their employees and to the severe detriment of the intent that the legislature, the AG, and the Skyline Court recognized. This Court of Appeal abdicated its responsibility. It should have done what the Skyline Court did. It had the words regular rate, it had a factual scenario, and instead of analyzing what that means under California law, it went and said, we're going to apply federal law that is the antithesis of what the California law requires. It's as if Justice Kennedy said on a prohibition on same-sex marriage. Justice Kennedy said...
Can we go back to Justice Kruger's original question?
Sure.
What does the term legal maximum mean?
Legal maximum means 40 hours in a week or 8 hours in a day. By legal maximum, it's the legal maximum before overtime kicks in. That's what it means. So, that's clear from the use of the approach taken in the Skyline and the approach taken in the DLSE manual. And I think that it's important that a message has to be sent to courts of appeal when there's ambiguous terms like regular rate that you just can't punt. You have to, as you said in Augustus versus the ABM, you have to look at the intent and purpose of the law and determine the definition from that. 20 years ago, I argued Ramirez versus Yosemite Waters before this court. And in Ramirez, this court said, even where the language is the same or similar, if the purpose of California law is different than federal law, you have to apply the intent of the California law. And you cited Skyline to that effect. The same should happen here. The words regular rate are used in both statutes, but the intent of California law, through several reenactments of it, is different than the intent of federal law, and that has to be preserved.
So you had argued earlier that this isn't a sort of true bonus of the sort that perhaps the federal regulations talk of when they talk of calculating the bonus rate by including total hours worked, including overtime hours. How do you think federal law does deal with this scenario where you have a flat sum bonus that is in effect being used to provide additional compensation for working a less favored shift?
Well, I briefed a lot about federal law, and there's a Saturday and Sunday premium federal regulation, different than the bonus regulation. And in the Saturday-Sunday premium regulation of the federal law, it says you're not supposed to credit the Saturday and Sunday extra pay towards the calculation of overtime. And so I frankly think that the federal law should treat the bonus the same, this pay plan the same way as state law. But I'm not sure,
Do you acknowledge it's different?
It's different. To me, the federal law is kind of schizophrenic. And it has these Walling cases which talk about dividing by the total amount, but then it has these regulations like the Saturday and Sunday regulation and other regulations about artificial bonuses and things like that, which say you don't credit any of the overtime hours towards the calculation of regular rate. But we don't have to get there because the important thing is it's so settled in California law that you don't apply federal law. And you clearly don't apply fluctuating work week law. I'll reserve the rest of my time for rebuttal unless you have any more questions.
Thank you, Mr. Moss.
Thank you.
Good morning, Your Honors. May it please the Court, Howard Golds of Best and Krieger on behalf of DART Container Corporation of California. There are three fundamental facts in this case which we think are relevant. The first is that as to what DART did and its payment of a 15-hour attendance bonus, there is no California law, regulation, or case that governs how the overtime is to be calculated. Second, there is a federal regulation that is precisely on point. And third, to the extent the appellant's argument would be accepted, DART had no notice of what is going to be a change in policy in California.
Does the DSLE manual specifically address this issue?
The DLSE manual does address this issue.
And what should we do with it?
Well, in Tidewater, you said it's not a regulation. To some extent, I think that the...
What else did we say in Tidewater?
Well, you didn't say anything as to this particular bonus. In that particular instance, you found relating to people who worked off on an oil drilling platform and worked overtime, which is not similarly factually to what we're dealing with here. Here, we're dealing with a specific situation that is covered by a specific federal regulation.
How did we deal with the language in the manual in Tidewater?
Well, there are, like in Skyline, there are times where this manual is cited. Our concern is that it sort of is going both ways. On the one hand, this court in Tidewater says the manual is not a regulation, it is void. And in Marin, that gets carried forward as well. But nonetheless, what appellant would argue is here we have Skyline, which is this case from 31 years ago, that we nonetheless should follow. So there's a sort of being caught in both directions.
Well, I don't disagree with how you have described the landscape, but if you were to look at the policies of California and our efforts to discourage overtime, and that we have time and again said that the labor code is to be construed in a remedial fashion, and you have this underground regulation, and it's true that Marin was a different kind of bonus, and it's true that Skyline was salaried. Why is it that that's not enough, understanding what California's intent is, different from federal law, to have applied and looked at the APA underground regulation and said, well, it's certainly important that this is what DLSC thought is how this should be applied in this scenario?
Well, and let me put it the way I would do on behalf of my client here and other clients who I practice for. The policy issue is a genuine policy issue, which I understand and respect. The problem is that California wage and hour law is extremely complicated. It is full of pitfalls that even the most honest, upright employer can drop into if they do the wrong thing. It is constantly, if you're an employer, trying to be on alert to find yourself that you're not falling into these sorts of traps. And so to me, it is inherently unfair to say that DART should have discerned this policy from 31 years ago and should have taken it and applied it to a factual situation which is entirely different, and should have understood when it was computing the regular rate for these particular employees that it really should be following not the only regulation or statute on point, which happens to be the federal one, but it should have been reaching back 31 years and looking at a completely unrelated case, which was on its face limited to those facts, which then gets followed up by a state, by a statute, which doesn't deal with this DART situation either. And we should have said, oh, that's actually what we should be doing. From my perspective, this is not about the wisdom of the state's policy. The state's policy, whichever way it goes, I'm sure is wise. The question is whether DART has any notice of this. All I'm doing here, to be frank, is representing my client as opposed to trying to make policy for the state of California. And my concern for my client, and frankly for clients like mine, is how are they supposed to know? What are they supposed to do? You know, it's interesting, for example,
I agree with you, but if we're setting policy, should we end up in a position where however we calculate that the more overtime the employee works, the less the rate, standard rate? Should we end up in that position?
Well,
and isn't that where we end up if we follow the federal guideline?
And I agree mathematically, and unfortunately this case involves mathematics, which is not my strong suit, but mathematically, if you make that denominator smaller, you're going to make the rate of overtime larger. And if you then accept the premise that by making the rate of overtime larger, you discourage the use of overtime, then I cannot argue with that policy position. And I'm not here really to argue with that policy position. Whether I accept that or not, I'm not entirely sure, because of course the irony in this case is that DART's policy was meant to discourage overtime. What they were trying to do was get people to show up on Saturdays and Sundays so they did not have to keep employees who are on other shifts over on overtime. So
is your argument here essentially that if we were to rule against you, your greatest argument is prospective application?
That would
Because of
be,
the unclear nature of the law at the time and the federal law?
absolutely. I think that it is, I think DART, you could presume, would pay in whatever fashion the law required. And this is, despite counsel's claim to the contrary, the amounts of money we're dealing with in DART's situation are extremely small. That's part of the frustration here. We're dealing with a $15 or $30 difference over 2 weeks.
Can I ask you, under the, just shifting gears for a moment, under the DLSE manual, I just want to return to this question of whether there's a difference, as you understand it, between the treatment that the DLSE manual prescribes for a end of shift flat sum bonus, like the one at issue here, versus shift differential pay. So if DART had instead paid an extra $189 per hour.
I don't believe in terms of the regular rate calculation. I would agree with counsel. I don't think there would be a difference. I think mathematically it ends up in the same place. I would say, and I just want to reach back and do this, this case was decided on summary judgment in the trial court on a stipulated statement of facts by which everyone stipulated this was a bonus. So I do believe this is a bonus, and I think that's what the record before this court shows, is that it's a bonus.
And so you agree that if the DLSE manual were contrary to fact, if it actually had been properly promulgated and were a binding regulation, that the DLSE instructions about how to calculate a bonus would apply?
Were it a binding regulation, yes, but that obviously fundamentally goes to the problem that we have is it's not. And this court having said it's not, it just does seem, and I'm being repetitive here, but it does just seem unfair to say you should be following Skyline because that's precedent, but here's Tidewater and Marin, which are also precedent, and say it's not a regulation, but you should have sort of followed it anyway. And really that's what appellant here is arguing. And so it is just unfair. I would add that in our reading of Skyline, Skyline is the language regarding the calculation of overtime and the calculation of the regular rate is really just dicta. It is not the fundamental holding of Skyline, which goes to the question of the applicability of the 8-hour overtime rule to the flexible work week. In fact, the perhaps irony here is that if you read Skyline, I believe it's at page 245, what they're doing is that court is repeating the DLSE manual, so that what I will charitably call holding in Skyline about how the regular rate is computed is nothing but the Skyline court repeating what the DLSE manual says. And then, of course, the Skyline court goes on to find that the DLSE manual is, in fact, a regulation, which later gets overturned by this court in Tidewater. So there is a certain circularity here, which is that Skyline, which is the precedent that is most cited in this case, is basically quoting the DLSE regulation, which itself ends up not having any force or effect based on Tidewater. And yet, nonetheless, that's the precedent that appellants argue we ought to be following. In the same manner, we would argue that Marin, and it is of note that appellant in this case has, in fact, their theories have evolved over time and with each court, that appellant's original argument in this case involved Marin, which is also inapplicable, and which, interestingly, while it does not dispute the principle that this court is concerned about, the policy principle, it actually finds a different conclusion because it reaches a conclusion not based on computing the regular rate based on 40 hours, but actually computing it based on 1,000 hours, which was the amount of the minimum number of hours that Costco required the employees to work to qualify for the bonus in that particular situation. So while Marin does pay some, well, Marin does talk about how to compute bonus and is concerned about reducing the amount of the regular rate based upon the number of hours worked, it does not endorse specifically the use of 40 hours. And that is of note as well. Fundamentally, where DART is in this case is that we are interested in and in fact attempted to comply with the law. There is nothing here that indicates that DART acted in bad faith or otherwise did not attempt to pay their employees what was owed. It followed the one federal regulation, and there's no dispute that 778.209B of the CFR not only applies but is the only written statute, regulation, or authority that covers this particular situation. And so I would conclude by saying, again, from my standpoint, this is not about policy, this is about liability to DART. And from DART's perspective, what were they supposed to do? And with that, I will yield to my co-counsel.
Thank you, Mr. Gold.
May it please the court, the most important point that I want to make is what this case is not about. Because everyone here agrees. Plaintiffs said this in oral argument today. They said it in their opening brief, page 38. They said it in their response to our brief, page 35 and 36. If a bonus is earned over a combination of straight time and overtime hours, the federal formula applies. You divide by all hours worked, and you pay a premium equal to 0.5 the regular rate because the bonus itself supplies the straight time component.
Why does the federal formula apply?
The federal formula, the logic behind the federal formula is that you allocate a bonus to the period over which it's earned. And if a bonus is earned during both straight time and overtime hours, it has to be allocated to those hours.
But under California law, why would the federal formula apply?
California law is no different on this point. California law differs on salaries. And to the question about is base pay distinguishable from incentive pay, absolutely it is. For one thing, Labor Code Section 515D codifies a rule. It says that this formula applies to salaries, no other form of pay. Skyline involves salaries, no other form of pay. And getting at the question:
is California law more favorable, overtime law more favorable to employees?
With regard to salaries, yes. With regard to daily overtime, yes. But there's a fundamental difference between base pay and incentive compensation. If you look at the rule in Skyline, and if you look at 515D, there's something about paying an employee a fixed amount, no matter how many hours that employee works, whether it's 10 hours that week or 80 hours that week, that blurs the distinction completely between an exempt salaried employee and a non-exempt employee.
And if in calculating the overtime, however you do it, if you end up with more overtime, you get less rate of pay. Is that what California intended?
Well, no, but I think the question presupposes that you're not gaining anything by having worked overtime. May I use an example to illustrate it?
Of course.
Let's say an employer has a flat sum bonus. I'll pay you $500 if you complete a project. An employee works straight time hours to complete that project. They work overtime hours to complete that project. They're doing everything they possibly can to get that $500. And if they didn't put in all of that work, they wouldn't get the 500 hours. Even plaintiffs not taking the position that that would be divisible only by straight time hours, and a 1.5 premium would be owed because you allocate the payment to the hours over which it's earned. It's no different.
Do you disagree with your friend on the other side that if you calculate the overtime based upon the federal requirements or the federal standard, as opposed to the DSLE manual, that there is a difference and it does not favor the employee?
The difference is that the DLSE manual, by its terms, it doesn't apply to all bonuses. Let's start there. It applies to bonuses that the DLSE defines as flat sums. And what the DLSE says is if the amount is predetermined, and it's not going to increase, it's not going to decrease, it is what it is, then that's a flat sum payment. I think the fallacy in that argument, or in that position, is that every bonus at some level is a promise that if you do X, I'll pay you Y. And the fact that Y is a predetermined amount doesn't mean you're not rewarding the employee for all of the effort that they put into it, including the overtime work. If you go back to my example of a project completion
And what
bonus,
is the answer to my question?
the answer to your question is that the DLSC manual does differ from federal law as to flat sum bonuses, but
And the result is?
the result, according to the DLSC, is that you divide only by straight time hours and pay a 1.5 premium.
The straight time hours actually worked?
I think that's an open question, Your Honor, because 515D1 says
Or
you divide it by
the
40.
maximum straight time hours?
Yeah. I would argue it's 40 because that's what 515D1 says, but I'm not aware of any case law or administrative guidance that addresses that point. But even the DLSC's rule doesn't apply to all bonuses, and the justification for the rule doesn't apply to all flat sum bonuses. The example that plaintiff's counsel gave in court is if you complete 500 widgets, I'll give you $1,000. I forget the number of widgets in the monetary amount, but in effect that was the example. That's a flat sum. Why the amount is predetermined, but just because the amount of the bonus is announced in advance, that's true for countless bonuses. These bonuses abound. That doesn't mean that the bonus isn't earned over a combination of straight time and overtime hours.
So in this particular instance where the bonus is earned for completing a single shift on a weekend day, does that mean that we should think of the bonus as having been earned just over those 8 hours of the shift?
It depends whether you credit the DLSC's formula or not. I mean, what I would argue, Your Honor, is that there's a rule that's applicable to salaries, and the parade of horribles argument about employers will reduce base pay and call things a bonus that aren't, that's been unlawful for 70 years. The federal regulations at 29 CFR 778.502 say that wherever the employee is guaranteed a fixed or determinable sum each week, no part of that sum is a true bonus. And the rules for determining overtime when bonuses don't apply. That's the definition of a salary. And so if you conclude that this payment is a salary, you shouldn't throw the baby out with the bathwater and say that this formula extends to all bonuses, because the rationale for the rule doesn't. The same regulation defines a bonus. What it says is that a bonus is a sum paid in addition to total wages, usually because of extra effort or reward for loyal service or as a gift. So, if we go back to my example of the project completion bonus, it's earned over a combination of straight time and overtime hours. All of that effort is what entitles the employee to the bonus. They wouldn't receive it if they didn't put in that work. That applies to a safety bonus. A safety bonus doesn't just reward an employee for not having an accident during straight time hours.
When you say they wouldn't receive it if it weren't for that work, do you mean that if it weren't for all the work that they did, just explain what that means exactly.
What I mean is that the payment is a reward for all of the work, not only for certain work. I mean, even an attendance bonus, my view of an attendance bonus is it's not a reward for showing up and leaving. It's a reward for completing your shift reliably, routinely. You show up and you complete your shift, whether I've scheduled you for 4 hours or 10. An attendance bonus rewards an employee for hours worked during straight time and overtime. And that's why the federal formula applies.
But what if what you say is true, but what if that is contrary to California's purpose in enacting this statute and these regulations, when the whole point is to de-emphasize overtime and to be remedial in nature, because the effect of what you're saying, as is acknowledged several times, is it dilutes the employee's hourly regular rate of pay.
Right.
So in fact, the more they work and the more bonuses they earn under the federal formula, the more it inures to the detriment of the employee. So we know in California that's what we try to avoid. So how do we bridge that gap of that interpretation that results in detriment to the employee?
Right. And I'm not asking you to jettison California's public policy by any means. Skyline exists. Labor Code Section 515D exists. I do think there's a reason why they are focused on base pay. And there's an issue where an employer takes what really is an incentive payment, what really is base pay, and artificially labels it a bonus. The law already protects against that. And even if you credit the DLSC formula as to some fixed sums, it shouldn't apply to every fixed sum bonus. I mean, I cannot tell you how many employers have bonus plans that say, if you do X, I will tell you Y, where Y is a known quantity. In the short run, you would be penalizing employers who have all sorts of pay systems that don't resemble this at all. In the long run, employers will stop paying incentives.
So what do we do here where your interpretation doesn't square with California's interpretation or California's purpose of our application of overtime protection?
Two things, Your Honor. I disagree with the DLSC's position in its manual. Even if you credit that position, don't go beyond what they say, because there is such a thing as a production bonus, and even the manual credits that.
So what would if you had to describe an appropriate scope to give the DLSC manual instruction, what kind of bonuses do you think that instruction could legitimately apply to?
Well, bonuses that resemble salaries. I mean, a salary has 3 features, and this is in the reg that I quoted earlier, 29 CFR 778.502. It's also in 29 CFR 541.602. The language is slightly different, but you'll find all 3 features there. It is guaranteed, it's regularly received, and it's a fixed sum.
So
not every fixed sum is a salary.
So would you say, so the DLSC manual, for example, it gives the example of a flat sum end of season bonus, and it's guaranteed only in the sense that you will get it if you remain through the end of the season, right? It's designed to incentivize a contingent event.
Right.
Is that guaranteed in your view?
In my view, no, because that is a reward for remaining employed for an extended period of time, and it's a one-time payment. I mean, take, for example, I could give you dozens of examples, but a sign-on bonus. An employer says, thank you for coming to work for us. Here's $5,000. I don't want to be hoodwinked. You have to remain employed for at least a year, otherwise you owe me this money back. That's really functioning like a retention bonus or a relocation agreement. I'll pay for you to move across the country. I'll give you $5,000 to do that. But again, I don't want to be hoodwinked. You have to remain employed for a year. You're rewarding the employee for all of the work that they put in over the course of that year. It's not a regularly recurring guaranteed payment.
May I ask you a question?
Yes, Your Honor.
The Chief asked you a very direct question, which is, under the facts as you posit them here, and you argue here, the employee loses. The employee comes out with less the more the employee works because the denominator cuts the salary the employee is going to get. Is that not correct?
I don't agree with that. The reason why I don't agree with that is because just because the amount of a bonus is specified in advance doesn't mean that the employee is getting nothing for having worked overtime, for 2 reasons. One, if you didn't work overtime, in the example of the project.
The question you were just asked, sorry, counsel, does not imply that the employer is getting nothing, just that the employer is getting less.
That's correct.
Well, of course, mathematically, if you divide by a fewer number of hours and you apply a premium that's 3 times as much, employees get more, but that doesn't mean it's the right result. No matter what this court does, don't go beyond the manual, and please take into account that fixed payments where the amount of the bonus is defined in advance, aren't all salaries. They're not all designed to circumvent overtime requirements, and I think that the definition of a salary really does provide a framework for this court. Because if you want to protect against employers doing what plaintiff's counsel warned about, reducing base pay and labeling something a bonus, there have been regulations for 70 years that have prohibited that. You don't have to engraft a new state law to prevent that.
Thank you, Mr. Hutton.
Thank you.
Do you agree with your friend on the other side that we should not go beyond the manual?
Well, I think, yes, you shouldn't go beyond the manual, but I think more importantly, this is a situation where this is not a production bonus. This is not a safety bonus.
Is it a flat sum bonus?
It's a flat sum amount irrespective of what the person does. And
is it covered by 49.2.4.2?
Yes, it is. And it is a salary. If you look at the definition of salary...
Should we go beyond that?
Pardon me?
Should we go beyond 49.2.4.2?
I think you may have to. This case, it does not involve those other issues, production bonuses, safety bonuses. They're paid that $15 when they work on a Saturday, whether they work overtime, whether or not they work
And your
overtime.
friend on the other side does not want us to go there.
Pardon me?
Your friend on the other side does not want us to go there.
I don't think you have to go to the issue of production bonuses. You could write a decision which talks about a fixed amount that is fixed irrespective of whether a person works overtime or not. That's what this case involves. It doesn't involve a situation where you're paying somebody extra for making 1,000 widgets during straight time and overtime. That's a different case. That case is not before you. The case before you is a bonus that you get whether or not you work overtime, just like the salary.
Isn't the same true of the production bonus? I just want to be clear on understanding your formulation of what you think a limited scope of the holding you're asking this court for might look like. I mean, I assume that in the production bonus scenario, the employer doesn't care whether the employee works overtime or not, as long as the production goal is met.
That's correct. I've been an advocate for employees for a long time, more than 40 years, but the formula for a production bonus might be different. The DLSE took a different approach on the production bonus. They divided it by all hours worked because those widgets were manufactured during all hours. I would say no, you should divide by 40 hours no matter what the bonus is. As a labor lawyer for 40 years, that would be my position.
So in this particular case, would you say that because the bonus kicks in as soon as you've completed I assume an 8-hour shift, which does not include any overtime, that means that the bonus is designed to reward regular time work? If somebody's scheduled from Wednesday to Saturday, Wednesday to Sunday, and they work 40 hours, this bonus is designed to give them extra money for working an undesirable shift on Saturday and Sunday. It's a market-driven bonus or shift premium that has nothing to do with overtime hours worked. And that's what distinguishes this case from production bonuses or safety bonuses or those types of things. The attorney for DART started off by saying, well, we had to look at federal law because there's no state law involved. State law, that was what Skyline was confronted with. There was no regulation that said, if you have a salary, this is how you're paid. And the important thing here is Skyline did what it had to do, but since then, he was wrong. There is law that they could have looked to. 510 was passed. 515D said you don't divide by more than 40 hours. 515D2 was enacted before the decision of the Court of Appeal. And 515D2 said you only divide by the non-overtime hours. So the legislature gave DART the mechanism to do what was right. It was not just Skyline. 515D, can't find it right away, but 515D2 specifically says when a person's paid on a fixed salary, you only count that towards you don't count the overtime hours. And a salary is defined, as counsel for the Amici said, as a fixed amount that doesn't change based on quantity or quality of work. Well, here, that's exactly what this Saturday and Sunday payment is. It doesn't change based on the quantity and quality of work. It's $15 as a fixed amount. It's a salary under the definition. There's a case in California, Negri versus Koning, which I was also involved with. My son is the one who actually argued it, where the Court of Appeal ruled what a salary is. And it's irrespective of the quantity and quality of work, and 515D2 tells DART exactly what they should have done. So your decision should not be prospective. They had 515D2, and they had a DLSE manual telling them what to do, which cites to Skyline in the overtime sections, and even Marin, where they approved the flat sum issue, cited to Skyline. So you have the DLSE manual, you have Skyline,
There's no reason that this decision should just be prospective. There was enough for DART to know what it should do based on the law and the manual, which should inform your judgment. Thank you very much. I'm done.
Thank you to all counsel. Matters submitted, and we stand in recess. Thank you.
All right.